I'm so sorry. I'm sorry. Please. I'm so sorry. I'm so sorry for what they lost. So she's going to be going into custody today. Ms. Guerrero, she'll be remanded without.
This entitled woman showed up in court today after violating her probation by doing the one thing she was explicitly told not to do: drive. She's facing up to 20 years for vehicular manslaughter, a charge that exists because someone lost their life due to her choices behind the wheel while under the influence. That's what makes this case so heavy. There's no rewind button here. No second version where the victim gets to go home. And you would think someone in her position, someone already staring down decades in prison, would be extra careful. But clearly, that wasn't the case. Let me know in the comments how much prison time you think is deserved when a life is taken. Because honestly, there's no number that really feels like enough. Let's dive in.
And we have an issue with your client, Ms. Guerrero. Your client was driving and vaping, and she's charged with intoxication manslaughter. I don't know what the conditions are, but she may not be leaving the courtroom today.
Okay.
It depends on what her conditions are.
Okay. Is there any way to set her up on a computer right now to talk to me in private?
Yes.
So I can find out what's going on?
Yes, I'm going to send you to breakout room number 1. All right. This is what the court has discovered from reviewing the filings. Yes, a motion was filed where this defendant was allowed to have the remote in-home monitor installed in the ignition interlock with an affidavit of non-driving. So she's not supposed to be driving because she's using it in-home. So what she has done is she's violated her conditions of bond. So she's driving, and she's supposed to have, she's not supposed to be driving.
Okay. As far as I understand, I asked her about having a valid driver's license. I didn't ask her about the difference between the ignition interlock and the home handheld device. I'm sure that she would be more than amenable to have that ignition interlock placed on her vehicle. I do understand that there was an accident and her vehicle was not working, but maybe she has a new vehicle. I didn't get all those details, Your Honor.
All right, so that's what the court has, and that was dated on September 8, 2020. And the court doesn't have an order that's saying that she's going to be driving with ignition interlock. In my understanding, she doesn't have ignition interlock on her vehicle, and she should.
Okay.
So she's going to be going into custody today. She violated her conditions of bond. I can't have someone. And Ms. Smith, I don't take it as true that you committed an intoxication manslaughter, but you're charged with intoxication manslaughter. And one of your conditions was because your previous attorney came to me and informed me that you would not be driving. And so I allowed you to have the in-home monitoring device installed in lieu of ignition interlock if an affidavit of non-driving was provided. So you're driving and you don't have an ignition interlock. That's a problem. So you're going to be taken into custody today. Ms. Guerrero, she'll be remanded without bond. If you want to file a motion to have the court reconsider that or bring some more information to me, Ms. Guerrero, of course, the court will be more than willing to consider that. But for now, she is, I'm issuing a judge's warrant and she's going to be remanded.
Okay. Well, I'll visit with her tomorrow through the jail and I'll report back.
For anyone who doesn't know, vehicular manslaughter means causing a death while driving recklessly or under the influence. This isn't a paperwork charge. This is a life-ending one. And that's what makes it worse. She went out driving again after probation had already told her no. No excuses, no confusion. Just don't drive. Probation is supposed to be the warning phase, the final chance to show the court You can follow rules, especially when the charge involves someone dying. And yet, here we are. We jump ahead about a year in this case, and it's clear something changed. She looks different, worn down, whether it was drugs, stress, or the reality finally sinking in. This is not the same person we saw at the start. What do you guys think changed her?
And are you Ms. Smith?
Yes, ma'am.
Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your
Court will find that the state is in compliance with discovery. Ms. Smith, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the count 2 charge of manslaughter and waiving counts 1, 3, and 4.
No objection.
All right, Ms. Smith, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of manslaughter? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Judge, may I clarify one of my responses in response to your question about motions?
Yes.
I said that I hadn't filed any, and I'm not sure if Ms. Corley did, so I don't want to represent to the court because I think she may have filed some evidentiary motions. I did file some non-evidentiary motions, but I wanted to make sure that if Ms. Corley did, I didn't represent that there were none filed.
All right. And I can tell you from my review of the court's docket sheet that there was no motions that were heard.
Okay.
And there were some motions that were filed, but none that were heard.
I just didn't want to make any misrepresentation.
All right. So the court is finding you guilty of count 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
On behalf of my client, Judge, this is a case that was a tribal type case based upon the evidence that you reviewed. My client has made the decision to come in and accept responsibility for her portion in this accident that happened. She's extremely remorseful. She wants to get this behind her, and she wanted to say her apologies to the family that the area where this happened, the location was very dark, and she just didn't see that there was an accident in front of her. She has Graves' disease, and she's been pretty ill at the jail. So she's hoping that this time will pass, and hopefully that she can get her life back together. She was a home health care provider, and she did help a lot of people while she was out in the field.
All right. Anything from the state?
And we have victim impact.
All right. Anything you wish to say, Ms. Smith?
I'm sorry, please. I'm so sorry. I'm so sorry for what they lost.
All right. Anything else from either side?
No, Your Honor.
All right. I'm going to follow your agreement. I'm going to sentence you to 6 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. We can go off the record. So, Ms. Smith, there's going to be a victim impact statement. What I can tell you is I know that sometimes emotions and tempers run high because in this court, we'll deal, as your counsel will tell you, and the state will tell you, we're dealing with serious cases, major felonies. But I do require that everyone treats everybody with respect and kindness. So there are some persons who want to say something to you. Just listen, internalize.
6 years. That's the sentence for vehicular manslaughter in this case. And honestly, I'm left conflicted. We don't get to hear the victim impact statement, but we don't need it to understand the weight here. Someone is gone forever. She blames the darkness, but the evidence shows she wasn't sober. And the hardest part to read is whether this is real remorse or just a realization that prison is no longer hypothetical. This case is a brutal reminder that one bad decision behind the wheel doesn't just change your life. It changes everyone's. Driving isn't just about getting from point A to point B. It's about responsibility for strangers you'll never meet. So let me ask you, is 6 years enough for taking a life, or does it fall short? Drop your thoughts in the comments. And as always, thank you guys so much for watching. Don't forget to like and subscribe. I post daily. Take care.